5 seconds to go. Start. As has been recorded in the impugned judgment of the High Court, when the writ petition was taken up for admission on 14th May 2010, the fact that the petitioners had withdrawn the condition with regard to the provision of foreign exchange rate variation was considered, and it was also observed that such subsequent withdrawal could not affect the bid of the petitioners. However, on the submission made on behalf of the petitioners that the aforesaid condition was also included in the RFP submitted by respondent number 4, notice was issued in the matter. Consequently, while taking up the writ petition for final disposal, the issues framed for deciding the writ petition were centered around the said question. In fact, the first issue which was framed was whether a bidder could amend its bid by withdrawing a condition of the bid document whereby the bid was considered to be non-responsive. The second issue, which is an offshoot of the first issue, is whether a bidder would be entitled to contend that a non-responsive bid be treated as responsive since the offending condition was withdrawn after the bid documents had been opened. The third issue raised was with regard to the bid submitted by respondent number 4 and whether the same could be treated as responsive although the price offered by the said respondent contained a foreign exchange rate component which was to be considered at a particular rate. In deciding the said issues, the High Court held that since the terms and conditions of the price to be firm and fixed was one of the more important ingredients of the tender, the submission of a bid which violated the said condition rendered the bid non-responsive. The High Court observed that this was not a case of clerical mistake in the bid documents but a conscious change in the terms and conditions of the bid as submitted by the petitioners which could not cure the initial disqualification when the bids were submitted. The High Court took note of the fact that the bid of respondent number 4 contained the condition that its price would be in Indian rupees with a foreign component which would be converted in Indian rupees as on the date of opening of the bid. The High Court observed that the same did not violate the conditions of the RFP and that the said condition ensured that the price would be firm and fixed during the period of performance of the contract. The stand taken on behalf of the petitioners was strongly opposed on behalf of the respondent number 4 to whom the contract had been awarded. Mr. Ashok Desai, learned senior advocate, pointed out that the condition relating to the foreign exchange rate variation and the proposal of the respondent number 4 in relation thereto indicated a firm rate of exchange as on the date of the opening of the commercial bids and there would be no escalation of such offer during the subsistence of the contract as envisaged in the tender documents. Stop.